Kelly and Amanda, Wade Lay was sentenced to death in the 2004 murder of a bank security guard.
Daughter of a man murdered nearly 18 years ago is devastated. The killer has been given a stay of execution.
After all those odds, he beat it. And then I was born.
Lay is on death row for killing Tulsa security officer Kenneth Anderson.
Execution here in Oklahoma could be taken right off the calendar because of a new report about Wade Lay's mental state.
Lay's son Christopher was sentenced to life in prison.
Justice 17 years later. The victim's daughter, who was laid over 18 years ago, is heartbroken that the slayer has been granted a reprieve. In 2004, Kenneth Anderson, a security guard for a bank, was laid during a bank robbery. Wade Lay was scheduled to be executed in January, but that has been postponed while his mental state is assessed. According to Monique Anderson, her father Kenny Anderson was a true hero. "I only wish there was more time," Monique Anderson remarked. After serving in the armed forces, Kenny battled cancer once more. Monique claimed that although her father wasn't meant to become a parent, he was incredibly protective of her since she was a miracle baby. "After all those odds, he beat them and I was born." Kenny was laid by Wade Lay and his son Christopher at a Tulsa bank when he was a security guard.
Craig, Monique Anderson says is Kenneth's only child and says that her dad was a hero.
Daughter of a man murdered nearly 18 years ago is devastated. The killer has been given a stay of execution.
After all those odds, he beat it. And then I was born.
During a bank robbery back in 2004 in Tulsa, Wade Lay was supposed to be put to death next month for that murder.
I was here 1 minute and gone the next. I didn't have time to prepare. I didn't have time to think.
Lay's son Christopher was sentenced to life in prison.
In light of the events in Waco, Texas and Ruby Ridge, prosecutors claim Lay attempted to rob the bank in order to obtain cash and exact revenge on the government. Lay was given an ending sentence and was scheduled to be put to slaying on January 6, but a judge postponed the ending to determine whether Lay is psychologically fit to die. According to Lay's lawyer, Lay has a history of serious mental illness. "Wade fought so hard to get off the ending row. Why would we give him what he wants?" stated Anderson. Although Monique claims she doesn't wish anyone dead, she acknowledges that it has been difficult to wait an additional 18 years for this chapter to end. "My dad was here 1 minute and he was gone the next," Anderson recalled. "I didn't have time to prepare or think about it." Monique declared that she will keep speaking up for her hilarious and caring father. "I just want justice to be served and his legacy to live on," she continued. The state consented to hold off on the execution until a competency hearing. Christopher, Lay's son, received a life sentence. Wade Greeley Lay is scheduled for execution in Oklahoma on June 6, 2024 for the 2004 slaying of Kenny Anderson. Standby counsel in capital cases. In Tulsa County District Court Case Number CF 2004-2320, Wade Greeley Lay was convicted of first-degree slaying in violation of 21 OS 2001-701.7 and attempted robbery with a firearm in violation of 21 OS 2001-701.7. The jury found 3 aggravating circumstances. 1. That the defendant knowingly created a great risk of slaying to more than one person. 2. The slaying was committed for the purpose of avoiding or preventing a lawful arrest or prosecution. And 3. That a probability existed that the defendant constituted a continuing threat to society. Lay has perfected his appeal of these convictions and sentences. The facts in this case are largely undisputed. Lay does not challenge his convictions, but only the sentences he received for them. On May 24, 2004, Wade Lay and his son Chris entered the Mid-First Bank in Tulsa to rob the bank to fund the purchase of guns to avenge the United States government's attacks on Ruby Ridge and the Branch Davidians. The Lays believed that the United States government had become tyrannical and that they had to start a patriotic revolution as was done by America's founding fathers.
Execution here in Oklahoma could be taken right off the calendar because of a new report about Wade Lay's mental state.
Prosecutors say his intentions for the money were sinister. January 6th, his attorneys are asking for a stay in his execution to allow time for the competency trial.
Lay is on death row for killing Tulsa security officer Kenneth Anderson.
But that's now been put on hold to see if Lay is mentally competent.
Lay initially claims that he had no constitutional right to propose representation in the penalty phase of a capital trial and that it was an error for the trial court to allow him to represent himself in the penalty phase. Specifically, he argues that the increased scrutiny demanded by the 8th Amendment to the U.S. Constitution in a capital trial overrides a defendant's right to self-representation. However, the United States Supreme Court in Faretta did not impose any restrictions upon a defendant's right to refuse assistance of counsel except to state that the right must be knowingly and intelligently waived. Lay does not challenge the constitutionality of pro se representation at the guilt-innocence stage of his trial, which is as important if not more so than the penalty stage. Regardless, the court holds that a criminal defendant may represent himself at all phases of a capital trial, guilt, innocence, and sentencing. Lay next argues a defendant who represents himself in the penalty phase of a capital trial must be granted the assistance of qualified standby counsel. The court finds that the district court did not abuse its discretion when it denied his request for a second chair or standby counsel at trial. The trial court should have required standby counsel to be present at trial to assist Lay with his self-representation at all phases of the trial. In the future, the trial court should appoint standby counsel in all capital cases where an indigent defendant is representing themselves or herself. Such standby counsel shall be present at all court proceedings to assist the defendant in self-representation but allow the defendant to maintain control of the case. Lay versus Tulsa County District Court. Lay's waiver of counsel was valid for the entire trial, including the sentencing phase. Despite being informed of his right to counsel and the dangers of self-representation, Lay knowingly and voluntarily chose to represent himself. The trial court found no error in his claims of juror misconduct, which included failing to disclose his past relationships with a witness, Tammy Lay, and reading a newspaper account of the crime before trial. Lay argued that the juror failed to establish prejudice or harm by this juror's service. However, the trial court found no evidence of juror misconduct, and there was no indication that the juror had formed an opinion about the case or exposed other jurors to prejudicial information. Lay argued that it was an error for the trial court not asking potential jurors if they knew the potential witnesses in the case. As a result of this failure, he was allowed to serve on the jury even though he had previous contact with the defendant's ex-wife. The trial court has discretion over the manner and method of voir dire, and it is trial counsel's responsibility to examine prospective jurors and discover any facts that may affect their qualifications to serve. In his pro se supplemental brief, Lay argued that he was deprived of his constitutional right to present his necessity defense, which is legally unsupportable. The trial court allowed him great leeway in presenting his defense, but it is not supported by the law or facts. Lay argues that his constitutional right to a fair and individualized sentencing hearing was violated because the trial court failed to order a sua sponte, a sentencing stage severance from his co-defendant Chris Lay.
At Kelly and Amanda, Wade Lay was sentenced to death in the 2004 murder of a bank security guard.
Kenny Anderson was a bank security guard and was murdered.
Wade fought so hard to get off death row. Why would we give him what he wants?
Say it proves their client is not mentally competent and that the prison warden actually delayed its delivery to a judge.
State agreed to postpone the execution until a competency hearing can happen.
He also claims that the trial court should have instructed the jury that evidence introduced on behalf of or against Chris Lay could not be considered as evidence regarding him. Both arguments fail. Lay never requested severance and was granted Wade Lay's demand for a joint trial. He waived his claim for all but plain error, which does not exist. The instructions as a whole adequately required the jury to give each defendant separate and individualized sentencing consideration. Lay challenges the victim impact evidence admitted at his trial, claiming that a portion of the testimony of the victim's sister, Tanya Collier, was improper and that Collier and the victim's other sister, Camilla Tryon, displayed improper emotion during their testimony. These arguments are meritless. Lay requests consideration of its prior ruling that the jury need not find that aggravating circumstances must outweigh mitigation beyond a reasonable doubt before imposing the ending penalty. The issue has been addressed and denied. He claims that the trial court erred in failing to instruct the jury as required by OUJI CR2D 4-77, which requires that when the state relies in part on circumstantial evidence to prove the existence of the aggravating circumstances, all of the facts and circumstances taken together must be inconsistent with any reasonable theory or conclusion other than the existence of the aggravating circumstances. However, Lay failed to object to the instruction as modified, waiving all but plain error. The court reviewed evidence to determine the sufficiency of aggravating circumstances in his slaying case involving Lay and his son. The evidence showed that Lay created a great risk of ending another person in close proximity in time and intent to the slaying. Lay argued that the evidence was insufficient to support the aggravating circumstance that the slaying was committed to avoid or prevent lawful arrest or prosecution. However, the court found none of the aggravating circumstances invalid. In Proposition 12, Lay argued that his ending sentence was imposed capriciously, but the court found that it did not result from passion, prejudice, or other arbitrary factors. The jury was instructed on 6 specific mitigating circumstances and instructed to consider any other mitigating circumstances that existed. Upon reviewing the record, the aggravating circumstances outweighed the mitigating circumstances, and Lay's ending sentence was both appropriate and factually substantiated. The judgments and sentences of the district court are affirmed, and the mandat is ordered issued upon the delivery and filing of the decision. That's all for this video, folks. See you next time.